Okay, evening everybody. And as usual, can I start with my usual request? If you could join me in turning your phones off, that would be appreciated. I will post something on Keats, but just some very advanced notice that we are fortunate here to have a lecture at 6:30 p.m. on the 7th of November, being given by Lord Collins of Matsbury, who is the most distinguished and famous private national authority in this country, and arguably one of the very small number of most famous private international lawyers in the world. He will be speaking, as I say, in the Safra Lecture Theatre on the 7th of November at 6:30 p.m. with myself chairing. I will, either this week or next week, I will post something on Keats so you have the details rather than asking you to take it all down. Okay. Excuse me. Okay, so you will also know the good news that there is another class on Friday afternoon. We have a double header, and I think we're actually getting into some really interesting stuff now anyway. But let's just pick up where we were in talking about the common law rules. So where we've got to so far, we've got two types of jurisdiction as of right. We've got service out. And what we've looked at so far, 2 weeks ago, the basis of jurisdiction under this heading, but not yet, but we're coming to today, the discretionary element. On this side last week, we looked at what the claimant has to do, and we saw that the claimant has to show a good, arguable case. Whatever exactly that means, and we had some further thoughts on that with the Supreme Court in Brownlee, we looked at last time, may or may not have made it any easier. But the claim falls within, remember, this ungainly provisions, the civil procedure rules, practice direction, 6b, paragraph 3.1. That's where we got to last time. And we're going to be focusing on the discretionary element a little bit further today. But I just want to carry on, just finishing with a couple of other issues, first of all, on this side of the offence. Because even if the claimant can show that the claim falls within or a good arguable case that claim falls within CPR practice direction 6B, one of those bases that we looked at last week, is that going to be enough? What, if anything else, does the claim have to do to be given permission to set about? What else is required? Okay, you've all read the material on service hours. This is not a difficult question. Somebody tell me, what else do you have to do? You have to come within one of these spaces. What else do you have to show as a claim? Yeah, that's that requirement. What else do you have to show? Yeah. What exactly do you have to show?
What the court should exercise.
Yeah, in other words,
it's not the same threshold as.
If you just put it in ordinary English, literally Latin, what have you got to prove in English?
It's appropriate for them to the court to.
It's appropriate. Let me give you two options.
Yeah.
It's appropriate for the court to take jurisdiction, or of all the possible places that could take jurisdiction, England is the most appropriate. Would we go for A or B? B. And you'd be right to go for B. This is the discretionary element. And this all comes from a case I mentioned in 1987 that I mentioned last week, the case called Secon SAR. You may remember, SEACON-SAR in 1987. All of these requirements are stated there and have been stated many times since. The claimant has got to show that England is the often called the most appropriate forum, but you'll often see the phrase the natural forum, which means the same thing. And that natural forum really means the most appropriate. Of all the places that the case could take place, that England is the most appropriate. So that's referred to as the natural forum. Now, that element of the test is the discretionary element. You have to persuade the judge in his or her discretion that of all the places this claim can be heard, England is the most appropriate. So that's the discretionary element. That's a rule-based element. That's a discretionary element. And precisely because it's, as I think you already said, basically the flip side of the discretionary element on this side of the fence, it makes sense for me to take them together. So I'm going to put it on the board and then not say anything more about it until we work our way through the discretionary element. Because there's one other thing. And it has something to do with the merits of the case. What is that?
Is it a specific arguable case? And there doesn't have to be 2003.
What do you mean by that?
So there has to be merit to the case being brought forward.
Why? It's a matter of I'm not saying it's a matter of law, it's a matter of common sense. Why?
Otherwise, if you were to success.
Yeah, if you're talking about someone in New Zealand, you might be able to show that if there was a contract, it was concluded in England, for example. You might even be able to show that all the evidence is here. But if your claim is absolutely hopeless, then it doesn't seem a very good or very fair thing to drag somebody halfway around the world to defend themselves. So there is a merit to it. On the other hand, what's the problem with having an intensive merit element, a high standard of merit?
Then you would have to actually hear the case before the case is decided?
Exactly. It's like, the whole point of jurisdiction is to determine whether the court can go on to hear the merits. So putting a case like you've got to show that you will not balance the probabilities of win is exactly the same test as you'll have to show at trial anyway. It doesn't make any sense. It's prejudging the merits. Yeah. So there's a balance to be struck between, on the one hand, your proposition, which is don't bring someone here for a claim that is utterly hopeless, just in that, because it would encourage people to fire off any kind of claim, just trying to get some money out of somebody, hoping they will say, I don't want to come around halfway around the world, I'll give you something. And the proposition you're advancing, which is, yeah, but you can't conduct a trial before you actually get there. Both because it's illogical and because you don't have the evidence either to do it at this stage. So the court strikes a balance between the two, but it's not actually called the good arguable case test. So to be clear, the good arguable case test applies to that element, the one we looked at last week. good arguable case that you fall within one of the bases. Does anyone know what the test is? What have you got to show? It's a serious issue to be tried. I wouldn't let myself much room there. Serious issue to be tried. If I had more space, I would continue that to say serious issue to be tried on the merits of the case. What do you suppose a serious issue to be tried on the merits of the case means? That you're going to win? Yeah.
That it's more than minimal or trivial?
I think that's a very good explanation. The explanation that Lord Collins gives in a later case in the Privy Council that I mentioned, I think you may have mentioned last week, I think it's called Kyrgyz Mobile, which I'll mention again later on Friday, is it's about the same standard as what's called a strikeout test. You know, you can strike, if somebody launches, even in a domestic case, if someone launches a claim and it's obviously on its pleading hopeless, or in law it's obviously wrong, you can apply to have it struck out without going to trial. You know, that's an expedient way of getting rid of the case. And Lord Collins says much the same sort of test here. Exactly what you say. Not hopeless, arguable, but way, way below something like saying you're probably going to win. Well, well below that. Okay, credible, I suppose, is another way of putting that. Okay. And it's exactly that, to strike this balance between not allowing frivolous claims here, but also not having a trial before you've even got to trial. All three of those, as I say, the best authority is speaking on start, and all three of them, the claimant, I've made a mess of this group, the claimant must show that bit applies to all three of those. The claimant's got three things to do, and has to win all of them. Winning on 2 out of 3 will not get you permission to serve out of jurisdiction. Okay. So, what a contrast in 2018, let's say it again, between the person who could serve you because you happen to come to London for a couple of hours to go to, a horse racing or whatever, and presumption of jurisdiction as a right, and the person you have to serve out of the jurisdiction, we have to go through all three of these things. Okay? As I said a couple of weeks ago, you never invent that now. Now, I have, just to reiterate, now dealt with, on this side of the equation, that one, and because there's a much shorter point in that one, which shows serious issues to be tried on the merits. I haven't dealt with a discretionary bit, which is showing that there's the natural forum, because most of today's session is going to be about this discretionary element, and I'm going to explain how it applies on both sides. Because there's a discretionary element on both sides, I'm going to explain how it operates. Most of the differences, I think you've already hinted at this, are to exactly who has to prove what. The factors that are relevant or irrelevant to the discretion are pretty much the same. It's just exactly what you have to show in the end. Who has to prove it that changes slightly different. Okay. Now, I'm going to stop there and say this. That, in a positive sense, is all of the grounds on which an English court can take. We haven't got to the discretionary element. What we've now got on the board, all of the grounds on which an English court may take jurisdiction. It may take jurisdiction if there's a place of business in England or a defendant here to be served. It may take jurisdiction if there's a good arguable case that it falls within one of these rules and there is a serious arguable case in the merits. It may take jurisdiction. I just want to deal with a short point in 2 or 3 minutes. A number of the books talk about there being another ground of jurisdiction. And the ground they talk about is, and I think Hartley does as well, is jurisdiction on the basis of submission. But I think the books are a little, they don't mean to be misleading, and I don't mean to accuse them of it, but can be a bit misleading if you don't understand what it is. First of all, what do we mean by saying submission? What do we mean when we're talking about a case of submission to the jurisdiction? What is submission? Yeah.
You don't change the jurisdiction.
Yeah, you're happy to, let's put it in a wider sentiment, you're content as a defendant to be sued here. Yeah? Yeah? Now, let's ask another question. Are there different ways in which you can submit to a jurisdiction? Well, I guess the answer to that is yes. What ways could you submit to the jurisdiction of the English court? How could you do it? Go on.
Impliedly expressing.
Okay, give me an example of the most obvious express form.
They're following the court and claiming that you want to be sued the airline. Is the implicit way would be to just respond to the claim with
Okay.
jurisdiction.
I don't think you've actually chosen the most obvious one yet, although there's not much to choose. So there are various ways of doing it. I start my claim against you. You receive it, whether you receive it in the jurisdiction or not. You have to do what's called the acknowledged service, which is basically a form to say you received it. And you then have, in a commercial court, normally 28 days to indicate whether you want to challenge jurisdiction or not after receipt. If you don't challenge jurisdiction, or you tick the box saying, I do not wish to challenge jurisdiction, then you have submitted. Let me be quite clear, though. It's not technically correct to describe this as a third category. Because if you're overseas in New Zealand, I may have no idea whether you're going to be willing to submit or not, if you're not here. And I'm still going to have to go to the court, at least ex parte, and ask for permission to serve you out. You are then going to get that form, and then at that point you may say, actually, I'm not going to challenge. Okay? So I don't think it's correct to describe submission as a separate way of taking jurisdiction. There's jurisdiction as a right, there's jurisdiction with permission to serve out. I'm not going to know, or probably not going to know, if you're in New Zealand, whether you're going to object or not. So I'm still going to go to the court and get ex parte permission to serve you out outside of the jurisdiction. You're just deciding not to bring a jurisdiction challenge. Okay, but I've still got to serve you, because everything's linked to service. So I wouldn't describe that as a separate ground of jurisdiction. The other thing you might do, which is even more implicit, if you don't fill in any box, is rather than the first document you file with the court being your jurisdiction challenge, what might be your first document you file? I've sent a great big claim that's 50 pages long saying why you're liable. What might be the first document you file in response? A defence on the merits. If you file a defence on the merits, I guess that's what you might call it. You were probably talking about in terms of impliedly. If you file your defence on the merits of the claim, then by necessary implication you're saying, I accept that this court can hear the claim, but I'm not liable. So pleading to the merits. Okay? So no challenge to jurisdiction, or pleading to the merits, as it's often called. Again, not technically correct to describe those as additional basis of jurisdiction. If you're here, I've still got to serve you as a right. If you're not here, I've still got to ask for permission to ex parte to serve it out. There just won't be a full-blown challenge. Okay? So I don't like the suggestion in the books that this is some kind of separate ground of jurisdiction in that technical sense. Yeah.
What if it's with regards to the contract between two parties?
Okay.
And they specifically said, in case of a dispute, you will submit a report.
When I said a few minutes ago, you've picked two very obvious examples, but perhaps not the most obvious example. You've just picked the best example, I think. Parties may have agreed way, and in most commercial contracts will have done, way before there's any dispute. This may already have been settled in a contract. What kind of clause do we call that contract? Sort of clause that, yeah, a jurisdiction or a choice of court clause. There may well be a contract that says any dispute shall be heard in the English courts. So jurisdiction or choice of court clause doesn't matter which one you prefer, which one you call it. And I would call them, use that term interchangeably. But even if there's a jurisdiction clause, I've still got to start my claim by doing what with my claim form? By doing what? Yeah. And if you're in New Zealand, what do I have to do? I still have to go to the court. Of course, I'm going to get permission to serve out. But it might take, and in some countries, it still might take a very long time. Even though we've had a bargain, you might think a deal is a deal. You know, in some jurisdictions, you know, very, very, you have to go through a central agency and it can take 6 months or more actually to serve the document. So it's certainly true to say that jurisdiction clauses in some contexts will give you jurisdiction. And as you saw last week, for example, one of the contract grounds for service out was that the parties had agreed to the jurisdiction of an English court. So it's relevant to jurisdiction, but again, it doesn't remove the requirement of service, unless, and this is something you won't necessarily see as much in the books, one of the modern drafting practices, one I like and often try and encourage people to put into their contracts is a further clause that says not only that both parties agree to the jurisdiction of the English courts, but that they also nominate a solicitor or in their contract or an address where they can be served in England, which down the line makes it avoids all the need to serve out the jurisdiction. If someone has actually agreed that they will accept service in England, then they can't then say that they insist on service out of the jurisdiction. There's probably only one true way that type of submission that completely bypasses the service, the traditional. It completely bypasses the traditional service requirements. What would that be? I bring a claim against you for providing me with an effective cargo of goods, which I haven't paid for, because I'm not happy. You think there's nothing wrong with the cargo, and I haven't paid you the £100,000 under the contract. What might you try and do if I start a claim against you, saying you provided me with an unsatisfactory cargo? What might you be tempted to do? Well, I've sued you. I've agreed to pay you £100,000 for this cargo. You supplied it to me, and I've started a claim against you and said, I'm not happy with this cargo. It's not good enough. You may take out in the loop that it's fine. So when I start my claim against you, you might think this is an opportunity to do what in the English world? Sorry? What might you want from the English world? You might want something even more obvious than that. Yeah, for what? You might want your money. Okay. I see you bring a claim that you've supplied with unsatisfactory goods. Your defence is there's nothing wrong, and you want to add in a counterclaim, and I want the money. And it's an obvious threat, so this is still all the time. If you do start proceedings against our client as you're threatening, we will bring a counterclaim against you for everything. Solicitors do that all the time. Okay. Why can't the claimant object to a counterclaim? If I start proceedings against you saying these goods are no good in an English court, why can't I really object to you then starting a counterclaim? Yeah.
Because the case would be decided on the same facts and merits and legal considerations, so it's only right to hear the case to hear the case together.
Yeah, what we could say.
I would say that you cannot use the jurisdiction only in your benefit, but not when it's not on your benefit.
Yeah, I think both of those points are together, aren't they, really? You've started proceedings here. You as a claimant, by starting proceedings, we don't often think about it, have obviously submitted, because you chose to start proceedings here. You've submitted the English court by starting a claim in the first place. You are deemed, therefore, to have submitted to any claim that naturally arises out of the same facts, in other words, a counterclaim. That is genuinely a bit different, because, of course, the counterclaimer doesn't have to serve any documents. You could just put it in their defence, with a defence and counterclaim. There's no requirement to start the claim to serve it out of the jurisdiction. The other side have done the service job for you by serving it for you. So I suppose in a way that's the only one actually that gets rid of the normal requirements for service. So I mean it's technically true, it's completely true. Jurisdiction challenges don't happen if the defendant's not interested in having them. That's totally true. But I think it's important to explain that it doesn't necessarily avoid the considerable inconvenience that you still have to often go through to serve a claim form on somebody out of the jurisdiction and the delay and all of those things. And I'm not sure that's always very well explained. Yes. I'd say immediately it is different under the judgments regulation, the EU rules, where submission is unequivocally a separate basis of jurisdiction. But we're not talking about that today. Okay. Fine. Shall we move on to start talking about the discretionary element, which I think is the most important, the most interesting thing probably we've done so far. Can I say the way I'm going to do this structurally? Okay. And now I'm going to take you back over here. So I'm now going to complete the story, the other half of the coin, on jurisdiction as of right. The reason I'm going to do it this way is because there's much more to say about this, about the discretionary element, much more of the learning has been developed in the context of jurisdiction as of right, and then I'm going to explain to you how it works when the burden of proof is the other way around, or in the case of circumstance. So just to go back to basics, we've worked out when we're on this side of the equation whether the English court has jurisdiction, and obviously if the court doesn't have jurisdiction you never get to stage 2, but if the court does have jurisdiction, we're now to the stage where the court is asked to say, well, you do have jurisdiction, but please do not, in your discretion, exercise the jurisdiction that you have. Okay? That's stage 2. Now, asking the English court to not to exercise when you ask the English, if you're served as of right, you're not seriously going to be able to say, okay, you might be able to say, I don't have a place of business here, or I wasn't here, but assuming you were present here, you don't have any argument on the basis of jurisdiction, you're not going to be able to say, as the defendant, there is no jurisdiction. So you're going to have to ask the English courts not to exercise it. Formally, what are you asking the English court for? A stay. Okay. Let's start with the basics. What is a stay? It's not saying there's no jurisdiction, it's saying you should stay the proceedings. What is that?
Suspend the proceeding until this is suspended.
Okay. I grant it, it's easier to stop where you stopped. It's certainly suspending the proceedings. Suspending the proceedings in general? No. Suspending the proceedings in favour of another court. The English court would never suspend proceedings in the abstract. It would always only do so if there was another court that it satisfied should be hearing the case. And that will actually do it. That's why asking for a stay is never enough just to say, do you know what, English court, you shouldn't be hearing this case. You would always have to say, you shouldn't be hearing this case because the case should be heard in X or Y country instead. It's sometimes... you could say it's a positive tax in that sense rather than a negative one. It's not just England. It won't get you anywhere just to say England's a terrible place to have a trial. You shouldn't hear it, because the judge will say, yeah, but tell me someone that's even better, someone better. You have to identify someone better. So you are suspending, to use the language you use, the proceedings in favour of another court. But that word suspend suggests something temporary. And if it's temporary, when does it end? Or does it end? Well, I think the truth is that there are, in law, there are stays and there are stays. And the kind of stay that we're talking about in common law is pretty misleading, actually, because in 95% of cases, the case will never come back to the English court. To all intents and purposes, when the English court is granted a stay at common law, it is deciding it will not ever exercise jurisdiction. Now, formally speaking, you're absolutely right, it is suspensory. And if, to give you an extreme example, if the court stays proceedings because it says that they should be heard in country X, and suddenly there's an outbreak of civil war in country X, and the group is being persecuted, of which the claimant is part, the claimant can come back to the English court and say, look, things have changed so radically that you should lift the stay and let me sue here because that country is no longer appropriate for some kind of reason. So formally, it's convenient because it doesn't stop you coming back and asking for the stay to be lifted if something radically different has changed, like an outbreak of war in a foreign country. But let's be clear, 95% of cases, plus probably more, once an English court grants a stay, that is that. And that is very different to the kind of stays you'll see when we look under the European rules later in the course. So, formally a stay, in substance the court is saying, I don't want to hear this case. That's what's going on. Okay. So, what the English courts do not have is a rule that attaches particular significance to whether any other court got there first. You'll see when we look at the European rules that the European rules attach a huge significance to whether the English court was first or whether another European country got there first or not. Remember what do we call that Latin phenomenon where there are proceedings pending already in another country? What do we call that? Lis pendens. The position in the common law is, yeah, it's one of the relevant factors to decide whether we should give up jurisdiction, but it's just kind of one that gets thrown into the recipe to decide whether we should give up jurisdiction or not. There's certainly no strict rules to the effect that because the court was there first. You should be given priority. We do a bit more on that to come. Okay. So we need to say something now about the doctrine, the Latin doctrine, the famous Latin doctrine, which often describes this phenomenon of going to a court and asking it not to exercise jurisdiction. What is this Latin term that we're talking about? Okay, so we all know that this is called forum nobis, and what does that mean?
Basically, not appropriate forum.
Yeah, that's the best possible translation. The forum is not appropriate. But as I say, it's actually quite misleading because if I go to the English judge and say, this is not an appropriate forum, I will not win. Unless I posit, despite the word the norm in there, it's a positive test. I've got to show that somewhere else is more appropriate. Okay? And in some cases, I've decided on that basis, they may not have that much of a connection with England, but the facts may be scattered around the world. And the judge may not be satisfied that any other place is more appropriate. The English courts were remarkably slow, and I'm not going to take you through all the history, which I'm sure you've read about. The English courts were remarkably slow to adopt the doctrine of forum non-complainants. Where did it come from? Scotland. It came from Scotland, and the best known example of this is a case called from 1892 called Sin and Robinow. 1892. That's how old it was in Scotland. The idea of giving up jurisdiction because another forum was more appropriate. You'll find that case referenced, if you wish, at footnote 2 on page 226. So it took the English courts, actually, more than 90 years to acknowledge the same doctrine, that the same doctrine applied in English law. And for all those 90 years, because an awful lot of those cases involved disputes between England and Scotland in that time frame, where people were inherently less mobile, there were transactions that click of a button. The Scottish courts were giving up jurisdiction in favour of the English courts, and the English courts weren't reciprocating by giving up jurisdiction in favour of the Scottish courts. And I think the best example, if you can have a look on page 228, see, not the first indented quotation, but the second one. A case that's quite important, actually, and I'll be coming back to next week as well. You'll see right in the middle of the page, page 228, a case called Saint-Pierre. Which is, as you can see, 1935. Just look at what the defendant had to do to get the English court not to exercise jurisdiction in 1935. The defendant had to satisfy the court that continuance of the action would work an injustice because it would be oppressive or vexatious to him, or would be an abusive process of the court in some other way. So that's what you had to do. Let's put this in context. You come to the horse racing, and the example that we saw in Grosvenor and Wiltshire a couple of weeks ago. You're here for a few hours, you're so complainful. To persuade the English court not to take jurisdiction, you're going to have to show that the proceedings are vexatious or oppressive or an abusive process. I'm not asking you to define them exactly, because we'll look at those concepts a bit more in the context of antecedent injunctions. But what sort of thing do you get the sense vexation or oppression means? What's a claim that's vexatious? Yeah, almost. Bringing litigation that has often with no real prospect of success, just to cause maximum inconvenience to the defendant. Not many people do that, but some people might do it, particularly if the other person's on the other side of the world and they think that they'll get some money out of them. If they start proceedings against them, they'll do anything to get rid of them. Vexatious almost means no real point in the litigation or no real prospect of success in the litigation. And we'll refine that definition next week. What about oppressive? What sort of thing does that conjure up to you? What will make litigation oppressive? Oppressive to who? To the court or to the defendant? Yeah, I mean, it's deliberately trying to make life miserable for the defendant, perhaps by starting multiple sets of proceedings in different countries at the same time, or deliberately choosing the most car-flying forum for no good reason. But let me put it this way, because I think it's enough this night. These are terribly what is called subjective concepts. And nothing to do with, is England more appropriate than Argentina to hear this dispute? It's much, much, much higher the bar. It doesn't matter how much I argue as a defendant. I was in here for a few hours for the horse racing. The evidence is not here, the card is not here. Why should we be sued? Won't get me anywhere. I have shown this almost subjective element that the claimant was virtually trying to punish me by starting these proceedings. It doesn't quite say that. But it's almost like bad faith the court is talking about. Abuse of process of the court to be here at all. Let's just put that into context, because that was 1935, but that test survived for 50 years, for another 50 years. So we are talking in the scheme. You've already seen how old the English law of jurisdiction is. We're almost, I wouldn't say we're quite talking about 5 minutes to midnight, if it was a day clock, but we're talking very late in English history. The English courts have, for the English courts seriously to have any serious discretionary test at all. Because that one was so high that hardly anyone would win it. So what we're talking about until the mid-1980s, 30 years ago, was, if you served somebody while they were here, 90% likely or more, you would actually be able to go to trial against them. Simple as that. And you could say, well, at least it's simple. It's a lot clearer than what we've got now. We don't have people, lawyers, earning a huge amount of money arguing about forum non-convenience, for days and days on end, and producing huge amounts of evidence that doesn't really feel like it belongs at the jurisdiction stage, rather than being a trial. Pick up what you made before. But that's what you get. When you make the test more liberal, you get more arguments. But that's not but from a defendant's point of view, remember what I said about weeks ago, how the claimant has all the cards in international litigation. Astonishing power for the claimant. If only you could, if you can get that person, find that person, hire a private detective, see when they're coming into the country and serve them with your claim form. You were 90% of the way there. And I think it's generally pretty surprising that state of affairs survived for so long. And even then, even if the proceedings were vexatious or oppressive, if the claimant could show any advantage of which it would be unfair to deprive them if they weren't allowed to sue in England, and that could be anything, like damages are higher here than in Argentina, then the court wouldn't rather stay. And it was a series of cases in the 1980s that changed this quite rapidly in the end, but it took a long time, and I'm not to get there. First, and I'm not going to go through all the cases, but first is the so-called McShannon case, which is discussed on the bottom paragraph of that same page, which is in fact 1978. But starting then and over the next decade was when the route to forum to an idea of not subjective bad faith being required, but just the court shouldn't take jurisdiction if it's not appropriate, if somewhere else is more appropriate to do so. The first time that the English courts admitted they had a doctrine of forum non-convenience was as late as 1984. And that was in a case called the Abedin Deva, which you'll see. And I'm going to take you through the facts of it because it's history now. But it's halfway down, page 230, gives the reference to a case called the Abedin Deva shipping case. Follow that reference down, footnote 19, and you'll see it's as late as 1984. That was the first time the English court said that they would give up jurisdiction if there was another forum that was simply more appropriate. The most famous soundbite from that case, a very nice little soundbite, is you'll see right at the very bottom of the very last line of that page, at the top of the last page, a very famous quotation from Lord Gitlock in the Abede in Deva, where he says, "Judicial chauvinism has been replaced by judicial code." That's a nice way of putting it, because I can tell you, as late as the 60s, the 70s, there were kind of judgments from eminent judges like Lord Denning saying things along the lines of, well, the claimant's chosen to sue here. It's not necessarily the most obvious place to sue here, but who can blame them for their excellent judgment? We really are the best centre, the best place to get justice in the world, recognised around the world. Almost well done for that excellent choice you made of coming. It wasn't even cynical like it's good for business or anything like that. It was really sort of, oh, well done, excellent choice, And that's what the judicial chauvinism, I think, means. We think we're better. Well, we're not. And the rest of the world doesn't like it very much, believe it or not. We take jurisdiction over disputes that don't really belong here. But all the things that we talked about in week 2 were becoming true. Waiting lists were going up. These were the most expensive cases. They were taking the most time. Precisely because they usually did involve a jurisdiction challenge. A jurisdiction stage, but also when these cases went to trial, they were difficult to deal with. They were depriving people who had a closer connection to England of the ability to sue here. All those things were coming true as late as 1984. But even the Abede in Deva doesn't contain what I'd call a definitive statement of the principle of for and non-conveyance. There is a statement. It's kind of history now. I won't take you to it. You've all read it. Because it's 1987 when the law is finally laid down clearly as to what for and non-conveyance is all about. In undoubtedly the most important case that we've covered so far on the common law, undoubtedly the single most important case of all in the entirety of common law jurisdiction. Which case am I talking about? Notice the irony. When we come to look at the judgments regulation, European rules of jurisdiction, you can be forgiven from some of the hysterical reaction from English courts and some academics, frankly, for thinking that this dreadful new convention that was then called the Brussels Convention came into force in 1987 in the UK and totally disrupted this fabulous and seamless common law set of rules that we'd had for the last X number of hundred years that were perfect. In fact, it's simply untrue. 1987 was the same year as the Cyclone Saar case setting out the principles of service out of the jurisdiction in the Privy Council with the judgment of Lord Gough. 1987 was the year when the forum non-convenience doctrine was clearly laid out by the same judge, Lord Gough. And you'll see next week that 1987 was also the year where the same judge, Lord Gough, set out definitively the principles on anti-suit injunctions, but we haven't got there. Okay. Whatever else I tell you about how old English law is, this is not so old. It gives the lie to the idea that everything was settled. And I can say in one sentence, it depends how you look. 30 years ago sounds like a long time ago. It doesn't sound a long time ago if you think about how the rule on service as a right we can trace back with no effort to 1608 or something, in 2 weeks ago. Okay. And in that sense, the claimant has had all the cards, had it their own way for a very, very long. And remember, the obvious problem with the rules, as we talked about on service as of right, and we talked about 2 weeks ago, is they're so liberal that they force the defendant to do something, to spend money, take all the risk of challenging jurisdiction, to try and get the court not to hear the case. And in the old days, the test was so high, you probably wouldn't dare spend your money on that, frankly. And you were left with little choice if you had money assets to protect in England, but to defend the case at trial. The inadvertent consequence of what Lord Gough said in liberalising the ability to grant a stay
is that it's led to a complete explosion of jurisdiction work and jurisdiction challenges. It's much more worth challenging jurisdiction now because it's much easier to do than it ever used to be. And that has undoubtedly been an unfortunate consequence in one sense of what Lord Gough had in mind. There's a bit that's not extracted in what we're about to look at, where Lord Gough said that jurisdiction challenges should be over in hours, not days. Okay. He had in mind a simple procedure where the court takes an impressionistic view of where the most appropriate forum is. I've never been involved in jurisdiction challenges that's taken hours, not days, in the commercial court. They can take a very long time. People introduce all kinds of evidence about where the best forum is for trial, and they cost a fortune. And they're quite unpredictable, precisely because the test is more finely balanced now than it used to be in terms of the respective party. So, let's have a look at Spiliada. Now, the funny thing about Spiliada is it wasn't a case on service as of right, it was a case of service out of the jurisdiction. But Lord Gough didn't really mind about that. He just decided that the time had come for him unequivocally to lay down what the discretionary element of the test was, whether it was on this side of the equation or that side of the equation. And nobody in the intervening 31 years has ever dared to argue that Lord Gough didn't authoritatively lay down what the law is on forum non-convenience, and nobody would dare do that now. It would be a ridiculous thing to do because thousands of judges have applied and accepted the test. The other thing about the case, in some ways, was it didn't actually have that much to do with England. There was one of these shipping disputes between a ship owner and a charterer. And it was about sulphur. I don't ask you to any expertise about sulphur, but apparently you have to know what you're doing when you're storing sulphur on a ship. Because if it gets wet, it's ruined, but it's worse than ruined. It can start corroding things around it. And this is a dispute where a ship owner has chartered their ship and let somebody who's been allowed to use it, the Canadian party, who's used it to transport sulphur and apparently damaged the whole bottom of the ship because it's not been stored properly by the charterer. So this is a very angry ship owner suing a charterer about the way that the charterer has carried sulphur on its ship. So we've got a claimant ship owner who is actually from Liberia suing a charterer who actually carried this sulphur who's from Canada. All roads do not lead to London at this point, as you can see. Well, it is true to say that the contract between them was governed by English law. It is true to say that. There was no jurisdiction clause, mind you, but there was a clause saying that their contract was governed by English law. Where did this voyage go to? Did the sulphur turn up in a port in the UK? Where did it go from? It went to India. From where? Yeah, from British Columbia, from Vancouver in Canada. So this is a cargo that has gone from Canada, British Columbia, to India. And as I say, the defendant was served out of the jurisdiction because they were in Canada. The connection with England is quite tenuous, actually. And anyway, if you're thinking about a Canadian court, particularly in 1987, you could probably assume that their contract law and their shipping law was pretty similar to English law. That probably one could hazard a guess a judge in Vancouver and probably also a judge in India would be dealing with some quite familiar principles if they had had to have a trial where they were applying English principles. And anyway, this wasn't so much about carriage principles. This was really about negligent condition in which this product was carried, rather than the fundamental rules of law. It was largely fact-intensive. Was it carried properly or not? So I say again, all roads do not point to London. We'll come back to that a little bit later. Let's have a look at the test that Lord Gough sets down. May as well get straight to it. He says, have a look at paragraphs A and B on page 231. This is unequivocally, without any shadow of a doubt, I don't have to tell you this time there's any doubt like last week about what good arguable case then, I can say to you unequivocally, with absolute certainty, this is the definitive test of the doctrine of forum non-convenience in this column, this discretionary, that you'll see as a point. And he says at the bottom of page 235 that a state will only be granted on the ground of forum non-convenience where the court is satisfied that there is some other available forum having competent jurisdiction, which is the appropriate forum for the trial of the action, i.e. in which the case may be tried more suitably for the interests of justice. In general, the burden of proof rests on the defendant to persuade the court to exercise its jurisdiction to grant a stay. It is, however, important, and then I'll skip those few lines, and then the last part of that page, the last line of that page, halfway down there, halfway through, if the defendant has made that test out, the burden will then shift to the plaintiff over the page to show there are special circumstances by reason of which justice requires the trial should nevertheless take place in this country. Let me stop there and try and put that on the board with you. So Lord Goff has just told you what the test is. How many stages does it have? How many stages are there in this test? It goes on to give you some more detail, but in its central part, how many stages are there? There are two. Okay. Stage one. What must be shown? What's going to be shown at stage one? Okay. Another forum what? That is appropriate or more appropriate? More. Burden of proof? Who's got to show it? Defendant. So the defendant's got to show there's a more appropriate forum. What happens if the defendant fails to show that? That's it, yeah. In the ordinary course of events, that's it. The court's got jurisdiction of you. You can't show somewhere more appropriate. If the answer is no, it fails to do that, then the English court takes jurisdiction. If you fail at the first stage, then that's it. Common sense says. What if the defendant wins and shows that there is a more appropriate forum? Yeah, go on.
No, now the plaintiff must show that there is special circumstances that allows to reject the state.
Yeah, when you say special circumstances, what sort of circumstances? It's got to show that it would cause what if they had to go and sue them. So by definition now, we're talking about that forum's got more to do with the case. But I'm saying, well, it might, even if it's got more to do with the case, don't make me sue there because... What does he say at the top of page 231? It's right in front of you at the top of page 231. Because, yeah, it would. Let's turn it around the other way. It would cause me some kind of injustice. We'll talk about what this means in a minute. I'm just putting it on the board. Okay. If we get to that stage, the court will stay unless, and this is the second stage, isn't it? The claimant can show that it would be unjust to make it litigated in the. Let me put it this way. That it would be unjust to make it litigated in a natural forum, by which I mean the most. When I say natural forum, that's the same as most appropriate forum. So two limbs, sometimes called the two limbs of Lord Goff's test. Two stages, if you prefer. It doesn't really make any difference. It's a two-stage, two-limb test. And you can see that you've got two different burdens of proof as well. Okay. And obviously, if the defendant doesn't succeed in that second stage, then the court is going to take jurisdiction. When I say takes jurisdiction, what I mean is, what I really should say to be accurate, is the court's going to exercise jurisdiction. If the claimant does show the second stage, then the court will not. Which is no really more than common sense. Okay, the two-stage test. Before we go into look at each stage in a bit more detail, what is the difference? You've got two different tests and two different burdens of proof. So it looks like it's quite important to decide what kind of things are relevant to the first limb and what kind of things are relevant to the second limb before we go any further. What's intended to be the difference, before we look at the detail, what's intended to be the difference between limb 1 and limb 2 in terms of the sort of arguments that the court's going to hear? What kind of things are we talking? What's limb 1 about?
It's natural affinity.
Natural affinity, what's natural in what sense?
As in if all the actors and all the subject matter that the dispute took place in a different country, like the author has, it's more natural affinity to that jurisdiction.
More convenient?
One of the factors of that.
Yeah, that's good. What else? If it's more convenient, it's also likely to be less. Yeah.
Regarding the connection.
Yes, it's to do with the connection. But what makes a forum more appropriate is to do with factors like, what's more convenient in terms of exactly where's the evidence. It's to do with factors like...
Who could resolve this substance better?
Yeah, better in what sense?
In the better understanding, one could say, of the governing law of the contract.
I would say more easily, more efficiently, and less expensively, probably. Although I think the expense, when the English law has in mind expense, it tends to have in mind things like, sort of, will you have to fly witnesses from one country to another? Not the fact that England itself is a very expensive place to litigate the lawyer's judgment. Yeah.
But only in regard to facts or also in regard to law. So can you consider that some law may have more or more just provisions for this case?
That's a good question, and I'm going to come to the detail in a minute. I think the answer is, and I don't disagree with anything you were saying, limb 1 is about what I would sometimes describe as objective factors. They're not about the personal situation of X or Y. They're not about, oh, don't send me to Argentina, I've broken my leg and I can't get on an aeroplane and it'll be very difficult, Nothing to do with that. It's, what's this dispute about and where is it most expedient to have the trial? Expediency, in other words, and it's intended, and it's said in subsequent cases, to be an objective test. I'll come to, if I may, a little bit more to this question about the relevance of the law. But an example of something that obviously goes to why it's expedient, and therefore it's first limb, is what law governs the claim. If the English, imagine it was the other way around, this claim was governed by the law of Liberia, and I don't profess to know anything about the law of Liberia, so I might easily be wrong. But an English judge may say, that's going to be quite tricky. It's probably going to, all things being equal, be easier for a Liberian judge to apply Liberian law than it's going to be for me. Yeah? So that's an example of an objective factor. It's just, actually, it's plain common sense. It's easier to have it's more expedient to do that in, that's an issue related to the law in one sense. You ask me a different question, what if the law is very unfair or unjust? I think that's more likely to be relevant to the second part. At the moment, I'm only putting them on the board. I'm going to go through the detail in a minute. So if that is objective, I think it's, where I'm coming from, where I said that the second one is intended to be subjective. What do I mean by that? What sort of things are we talking about here? Talk about whether it's on paper the most expedient forum or not, it's personally unfair for the claimant. Why? It's the most obvious example. You might not get a fair trial at all, which I think also goes to the point you were making about the law. Time bars possibly, but you'll see that Lord Goff treats those as first limb in a minute. The sort of argument, I'm not saying they will be successful, but the sort of argument that would be a second limb argument is I should be able to sue here because the level of damages I can get is much higher here. I'm not talking about at the moment whether these would succeed or not. I'm talking about arguments that are subjective. Or in my example, I've broken my leg and I can't travel to that jurisdiction to give evidence. They're not about where's the centre of gravity of this dispute. They're about the individuals in their centres. Now, the point that Lord Goff is making at the bottom of page 231, that I just skipped over briefly in point B, is it's not like one person argues all of the things on the first limb and the other person argues all the things on the second limb. Both parties will argue furiously on both limbs. Why one says that England is an appropriate forum and the other one says it's not. Why one party says that it's unjust to be sent to a foreign forum and the other one says it's perfectly fair for you to be sent there. Both sides will argue furiously on everything. These are effectively, I think in law it's sometimes we get too excited about burdens of proof. What is really going on here is almost a tiebreaker. You know, if the court is not sure one way or the other because each set of evidence is equally plausible about whether the set of gravity it is, whether it's England or Argentina, then the court won't grant a stay because the defendant won't have proved the requirement positively that Argentina is more appropriate. If the evidence is unclear either way about whether the claimant would suffer an injustice, then the same story is true. The court won't grant a stay because the claimant has got the burden of proof. That, of course, doesn't mean that both sides aren't arguing every point furiously. And obviously they are. Next, can we look at limb 1 first, in a bit more detail? The defendant must show that there's another forum that is more appropriate. Before I get there, have a look at little a on 231 again, and have a look at the second line, and have a look at right at the end of that line. The court has to be satisfied that there is some other. What's the word we've missed out on the board? Available for. Yeah, that word in. Strictly speaking, I think there are two parts to the first step. You've got to show that the forum is 1, available as a defendant, and 2, that it's the more appropriate forum. There's 2 things there, aren't there? More to say on the second one of those 2 in the first limb, for sure. But we'd better work out why Lord Goff uses the word available. What do you think he means by saying we've got to show that there's another available forum? That might be one example, that it's not available. You know, it would be great to have a trial in British Columbia, but time has run out, as it, in fact, you know, it had on the facts of this case. What else could it mean? When else might a forum not be available? Yeah, and the human rights kind of examples and civil war and all these kind of examples. Supposing I said, I'm the claimant, okay? Well, you're all defendants. You're all the defendants. Well, I told you, Judge, I've broken my leg. I can't go to, I can't go to Argentina. It's a long way away. And the defendant hasn't satisfied the burden of proving that Argentina is available because they can't show that I can actually get there. Is that what available means? What's available and what isn't available? I suppose is the question. Yeah.
Does it one be that cause of action actually exists in that jurisdiction?
I think it could be that. But let me give you 2 examples. I'm going to be really quick because I'm behind, as I always am. Let me give you one example of a case called Connolly, which was, I decided, I guess, about 20 years ago. I'm going to give you 2 Actually, I won't. No. Better example is Mohammed, Bank of Kuwait. So this was a case in the 1990s. For those of you who might need a history recap, there was an outbreak of war between Iraq and Kuwait. Mr. Mohammed was an Iraqi national who was working, as it sounds like, for the Bank of Kuwait. His dispute was fairly obviously, in many ways, most obviously heard in Kuwait. It fallen out. But he said, as an Iraqi national, I can't sue in Kuwait because I'm not allowed into the country. The countries are at war. I'm not allowed into the country. And because the bank had a branch in London, tried to bring proceedings in London instead. One of the things that Mohammed, the claimant, said to the Bank of Kuwait is, you haven't proven that the natural forum is available because I can't set foot in it. I can't go there. Do you think he should have won that argument? That the defendant had failed to prove under the first limb that Kuwait was an available forum. In other words, what he's saying is, available means you've got to show that in practice I can sue them. Yeah.
But usually when the facts are obvious, there doesn't the other party doesn't have to bring any evidence if it's obvious. And the fact that there was war in Iraq was an obvious fact, so everybody knew that.
On the other hand, who do you think should have the burden of proof? Let me ask you put the same question another way. What Mr. Mohammed was complaining of, I can't sue in the natural forum because I can't go into the country. Do you think Lord Gough had in mind that that was an issue about availability and therefore first stage burden of proof on the defendant? Or an issue about an injustice to the claimant, on which the claimant should have the burden of proof under Limb 2? What do you think?
I think it's more like under Limb 2. It's because he's Iraqi, he's not allowed in. It's only not available to him because of the war. If the courtrooms had all been blown up during the war, that would be the first part of the case and say it's just not available to anyone. Or it's not objectively available because it's just physically not available to him. It's his subjective availability.
I'm sure that's right, but not what the Court of Appeal decided. The Court of Appeal said that available, that word available, meant that the defendant had to show that the foreign court was available in, not just in theory, but in practice to the claimant, that they could actually sue them. It led to a result that created massive criticism of the court. That it led to the conclusion that the burden of proof, that the defendant had failed to show that the Kuwaiti courts were available because they weren't available in practice. A few years later, in a case called Luber and Cape, which I'm going to come back to a little bit later, probably next Friday. In a case called Luber and Cape, so that's P. I could probably give you a case reference. Luber and Cape is, if you're desperate for a case reference, you'll find it on page 258 if you look at the context. And note 72. 258, note 72, you'll see a reference to Luber and Cape, which is as recently as 2000. Which was in the House of Lords in 2000, so the highest court, what now is our Supreme Court. Let me tell you what happened, because the facts are really interesting, and we'll come back to them when we talk about the second limb a bit more later. This was a claim, a test claim, brought on behalf of no fewer than 3,000 claimants. All of the claimants were minors. I don't mean minors in the sense of children, I mean minors in the sense that they worked in a mine. But unfortunately there isn't anything else that's very humorous about it because it's a terrible thing. They all contracted asbestosis poisoning. and the claims were either brought by them or by their widows. There were a huge number of them. The company they were working in mines in South Africa, and all of them were working for a South African subsidiary. None of them could get legal aid, in other words, public money. They were all extremely poor, and they couldn't get public money to sue in South Africa. So they all had these claims, which in theory the South African courts would definitely take jurisdiction over. Because they were all South Africans trying to sue a South African subsidiary in relation to events that occurred in South Africa. But that wasn't much consolation because they couldn't get the claim off the ground, they couldn't afford it. They could get legal aid to bring their claims in England. And one of the parties they tried to sue was, although formally separate, of course, was the English parent company of the South African subsidiary, which they said was actually heavily involved in what the subsidiary did, controlled it, was implicated in the providing unsafe conditions for the miners in South Africa. There's quite a lot at stake here. 3,000 people basically turning up in England. None of whom could really say England's the most appropriate forum. But all of whom were saying, in practice, this is the only place I can sue. There's nowhere else I can sue. In practice, this is the only place in town. The defendant has failed to show that South Africa is an available forum. And the House of Lords basically says, look, we've got great sympathy for you, but that's wrong. And to that extent, Mohammed Bank Kuwait is wrong. When Lord Gough said the forum had to be available, he couldn't have meant in practice available, because that would shift a large amount of what's the second bit in just unfairness to the claimant, just to think what you're all saying, and end up putting the burden on the defendant to show that the forum is in practice available to this claimant. And what the House of Lords said is no. Available means something much narrower than that. It doesn't mean available in practice. It simply means that it's a forum that is competent, or to put it in even plainer English, a forum that will exercise jurisdiction. No more and no less than that. And sympathetic as we are to the claimants, and they were very sympathetic, you'll see later, it's for you to show us the unjust element under the second. Available just means the defendant has to show that there is jurisdiction. In most cases, not all, but in most cases, that has, at a stroke, rendered the practical question of whether a forum is available or not virtually irrelevant. Because if the judge has shown any doubt about whether,
presumption of availability?
No, there isn't.
Would it not be available?
Well, if it didn't have jurisdiction under its national rules, which it may not. But the answer you give is not far from the truth, because if the judge starts saying, if I'm acting for the defendant, and the judge starts saying, well, I've got no idea, saying the Argentina's available, I've got no evidence before me about whether the Argentinian courts would take jurisdiction or not, how am I supposed to know? I might turn around to my client, probably warned them already, and say, do you know what you should do? You should offer the court an undertaking. What would that undertaking be? That if the undertaking would go as follows: if you do grant a stay of the proceedings, I undertake to do what in Argentina? Yeah.
To find the proceedings and see if the court makes it.
Well, I'm going to be the defendant. Something we talked about half an hour ago, 40 minutes ago. I undertake to do what if the claimant stops? Okay, what do we call that? What do we call that? I will
submission to.
I will submit. Yeah, and that's exactly what you would. Not every defendant is prepared to offer it, even though you tell them you've got to offer this, undertaking. Because some defendants want to have their cake and eat it. They want the case out of the English courts, but they're not prepared to make it easy for someone to sue them somewhere else. But that's the practical commercial advice. If you want this case to be heard in Argentina, offer a formal undertaking. And that means backed by sanctions like contempt of court, being thrown in prison if you breach it. Offer the court a formal undertaking that you will submit to the foreign court. And in 99% of cases, the court will say, well, almost every country in the world accepts jurisdiction if the defendant doesn't challenge jurisdiction. The issue of availability has gone away. So in practice, you almost never get cases now about whether a forum is available in that practical sense. I suppose you kind of, could get cases about wars and extreme examples, but there haven't really been any like that. So, available forum means having jurisdiction. I think we can conclude. But if you're doing an exam problem, it's easy to forget it. Make sure you deal with that question whether the forum is available. Then the defendant has to show the appropriate forum. Have we put that down correctly? The defendant must show that there is another more appropriate forum. Let's have a look. Let's go on to about 7 lines up to the bottom of page 232. See there's some dots. And Lord Gough says about 7 or 8 lines up from the bottom of that page. In my opinion, the burden resting on the defendant is not just to show that England is not the natural or appropriate forum for the trials, but to show that there's another available forum. That's the point I made earlier. It's not just, despite the language of forum non-convenience, it's actually a positive test. Not good enough to show England's inappropriate. You have to show somewhere else that's more appropriate. But look what he then goes on to say. There is another forum which is clearly or distinctly more appropriate. What does that mean? So if we're going to put this up correctly, we're going to show another forum that is clearly or distinctly more appropriate. In other words, not marginally more appropriate, but clearly, obviously more appropriate. If there's any doubt, the court will exercise that doubt against the defendant. Okay? The defendant's got. So I want to be clear with you now. We have moved a long way away from Saint-Pierre and defendants having to show vexation or oppression. But let's not exaggerate where we've got to. A defendant has still got a lot to do if they're served when they come here for 3 hours to go to the horse race. They're going to have to bring an application for a stay with all the cost risks, instruct English lawyers with all the expense, and they're going to have a pretty high hurdle to meet. They're going to have to show ultimately, as well as the forum being available, they're going to have to show that another forum is not just more appropriate, but much more appropriate. It would be untruthful to say that the pendulum has now equalled out, reached a state of equilibrium where the claimant and defendant have equal power under the jurisdiction of the court. They don't. Still a lot for the defendant to do, and a lot of cost risk. If you lose, you'll be paying everyone the other side's costs as long as you're right. Better it was, but one could overstate it. So we've got to show that the forum is clearly or distinctly more appropriate. What sort of factors is the court going to look at in deciding whether the forum is more appropriate or not? What sort of things is the court going to look at? Shout out in fact as you think. What sort of things would you, some of you have named them already, what sort of things would you be pointing to show that a foreign forum was more appropriate than the English forum? What might you point to?
I would say where the evidence was referring law.
Okay, both good answers. I seem to have left myself with almost no space, except somebody probably won't be able to see. Where's the evidence? Notice that's completely different to what we were talking about last week when we did that survey. We were on this side of the equation. It's not what the claim formally looks like it's about. It's what the underlying issues are that will be determined at trial. Do you remember I talked about the example last week of I supply you with a cargo of apples, that's how I deliver them to India, and you refuse to pay for them, you say they've gone off by the time you reach there. I say it's not my fault, don't blame the carrier. And I sue you in England for £100,000 payment. The English court is not looking at the £100,000 payment and where that was due. It's saying, what's this claim about? And what's the payment? It is about non-payment in a way. It says, well, what's it about? What's going to be the issue in trial? Yeah, the issue is going to be about, were these apples, what condition were they in? In other words, where's the evidence? If the payment had to be made to a bank account in London, but the cargo is in a port in India, which is the important jurisdiction there, England or India? That's the first one. In India, exactly. So it's what's the underlying issues at trial going to be, and where is the evidence? There is no hard and fast test here. It depends what the evidence is. Okay? If you're talking about documentary evidence in this day and age, it isn't very difficult to take a copy, put it on your screen, or put it out in a file, and saying that the document is stored in is formally stored in New York or whatever, is going to get you absolutely, you wouldn't waste your time saying it, with some kind of evidence. But obviously, there's evidence and there is evidence. For example, an example we'll look at later in the course under the European rules was a tragic case involving a diving accident on a beach in Jamaica. I think I mentioned that before. To understand whether there were sufficient warnings and what and whether it was a safe place to dive, probably going to need a site visit to do that. And that is an obvious factor pointing in favour of Jamaica. So I think it's not even as simple as saying evidence in general. It depends what the evidence is. It depends how exportable it is. If it's a document, what else might it depend on? The language is obvious. What are you going to need where, if you have a document, even if it's in a fairly common language, like say German, what will the court require in evidence? An official translation, a certified translation. Sometimes the two parties argue about what the translation is. You'll get the other side say, no, it means this. And then you'll find yourself with experts, written for experts, to say what this all means. It all depends. It's easy to write out evidence in the board. And I don't want to give the impression that it's as simple as that. It depends what the evidence is. But you can see highly discretionary factors, but where the evidence is going to be a huge part of it. Because it is more expedient, because it is, all things being equal, cheaper to go where the evidence is, not to have to translate documents. But again, it depends what the document is. The dispute is about what the exact meaning of a particular phrase is in the document. Then that's a reason not to be having a trial in England if the document is in an unfamiliar, if the document is in Spanish. If you just translate the document just to understand what the terms are and who has paid what amount of money to when, there may be nothing tactical in it, and the fact it's got to be translated may take a few hours time that you have to bill, and that's it. Yeah.
There was a case regarding that the governing law was not English law.
Governing law, can I come back to that in a second? Okay? Governing law, I think, is another point. Actually, why don't we put it up there now? Governing law. Tell me about what's the relevance of the governing law? Yeah.
This particular case would be tried by English courts.
Yeah.
And the governing law was a foreign law. The decision would have been of a factual nature regarding the foreign law, and that would limit the appellation way more than was tried by the natural court that was of which the governing law was.
Do you think it matters? There's two things. That's all true, but there are two things to say, I think. Firstly, do you think it might, supposing that this contract had been governed by the law of British Columbia, two scenarios. A, scenario one, this contract is governed by the law of British Columbia. Scenario two, this contract is governed by the law of Liberia. Do you think it would make, what's your feeling, what's your suspicion? Do you think it would make, in terms of the weight the court gives to the law governing contract, do you think it would make a difference between scenario A and B? First example is governed by British Columbia, or second is like, yeah.
Well, we have again this language issue.
Language, yes. Is it just language?
Probably they would be much more familiar with British Columbia law than Liberia.
I think that, although it's not, I can't prove it, in reality you know that's true. You're not going to make a great big fuss about an English court having to apply British Columbian law or the law of New South Wales, for example, or any other legal system, because the judge, the judge is going to be thinking, I'm going to be able to do that dead easily. Probably don't need experts at all, because neither side will actually plead any different. The way English law works procedurally is a party who's arguing that foreign law is different to English law has to prove it. And in quite a lot of these cases where the governing law is an Australian legal system or Hong Kong or Singapore or Canada
If it's continental law.
they don't bother. They don't, neither side actually bothers even to point to a single difference. So the judge doesn't have to do anything. If the law is very, very different, it may have more effects. There's governing law. Again, these points are not as simple as one bullet point on the board. There's governing laws and there's governing laws. And some disputes are very legal and intensive. Other disputes? A sad fact for us as academic lawyers is that we learn about academic law, but 90% of the cases are entirely fought on the facts, and there's virtually no law in them at all. Or if it is, it's not in dispute, all fact and evidence sense. It doesn't really matter what the governing law is if the entire dispute is a question of facts. What was the condition of those apples when they arrived at the port in India? Who cares? And in a case, not in Hartley, but worth telling you, in 2013 in the Supreme Court, in a case nice of you to remember the name, the BTB. This is what Lord Mance basically said exactly what I just said, that the significance of the governing law. Actually, I'll read you what he says. This is paragraph 46. He says, the governing law, which here is English law, is in general terms a positive factor in favour of trial in England, because it's generally preferable, other things being equal, that a case should be tried in the country whose law applies. You'll agree with that, I think. However, that factor is of particular force if issues of law are likely to be important, and if there is evidence of relevant differences in the legal principles or rules applicable to such issues in the two different countries in contention as the appropriate. Pretty much exactly what we just said, but then we've got a Supreme Court Judge Lord Mance saying. Governing law, sometimes very relevant, sometimes not really very relevant at all. I can tell you that most commercial court judges are pretty fearless about applying foreign law anyway, in my experience. You don't get, they will say it's a relevant factor, but they fancy their chances of being able to do it. On the other hand, it is more expensive, it is more unpredictable, both sides will instruct witnesses, expert witnesses. Professor X is very credible from Y University, and you'll have Professor A from B University, and the judge has got to sit there and decide what the law is. Yeah.
On a practical note, people appeal on the basis that the judge got the foreign law wrong. I would be able to say.
Usually, there's a very strange rule of law, which is expert evidence on foreign law, which sounds completely counterintuitive, is treated as a question of fact. And the reason for that is facts are much more difficult to appeal in the English legal system than points of law. So to answer your question, it does happen. The Court of Appeal will almost only ever interfere if it thinks that the conclusions on foreign law are not just wrong, but obviously wrong. Partly because it's a question of fact, not a question of law in an English court, what a foreign legal system says. But also for the really obvious point is that the appellate judge won't have seen the witness the experts cross-examine. The trial judge will have done. So it does happen, but you've got a pretty weak appeal if all you're appealing on is the judge got the foreign law wrong. It does happen. Not that often. Okay, well, there's an even more obvious question than this, which is very much more linked to evidence, which is where the witness is. You might say that is almost an example of evidence, but the convenience of the witnesses. And you might say, oh, come on, it's nearly 2019, they can give evidence over a video link. And it does happen, but I can tell you most of the judges over there don't like evidence over a video link. They want to see. I was going to say that I didn't want to see the witness squirming on the stand in front of them. And that's almost the truth. They want to see their body language. So people tell you about how much of communication is non-verbal. Don't ask me whether it's true or what the percentage is. But I can tell you a judge wants to see the person in front of them. English judges tend to regard, I'm generalising, but pretty much all the ones I've ever encountered, regard video link as a very poor substitute for actually having the person there. Okay. So where the witnesses are, how many of them, all of these kind of factors are convenient. They are convenient. It's cheap. You've got to fly in your witnesses. You've got to put them up in hotels. You've got to make sure they're looked after. You don't want them to be tired. You want them to be pampered and feel that they're going to be in top condition to give evidence on your client's behalf when they get there. It's obvious that they're expensive. If their first language is a foreign language, you're going to have an interpreter as well. Okay? All of these things are factors that are obviously relevant, in terms of where's the most appropriate for it. So that's equally relevant. So we've got those, I think, are hugely important factors. We haven't mentioned the residents of the parties themselves. If you've got two New Zealanders slugging it out in the English courts, the English court may say, well, why? Tell me a reason why you should slug this out here rather than in the courts of New Zealand. Co-defendants would be another classic question. It's very easy to talk about this as a claim between this claimant and that. You might get a case where, let's say, both. Supposing that I told you that claimant one and the claimant is from New Zealand, and defendant one is from New Zealand too, and in a way, you're thinking, what are these people doing in England? Okay. But if I now tell you that there's another 50 defendants, and none of those are from New Zealand, then if they were from England, this would not be a common law example. So let's say all of the other defendants are scattered all around the world. Some are from Russia, some are from New Zealand, some are from Argentina. Suddenly it doesn't look so obvious. And another thing I think is very important is, theoretically, if I am just one defendant out of 50, I can say, never mind about the other 49, I want a stay of my claim. But the reality is the judge, although they will consider that application, they will consider it in the context of the overall litigation. And they're probably going to conclude, look, if the other 49 are happy to be sued here, the worst possible result is to have a claim, massive trial with 49 defendants, and you having a separate trial in New Zealand. So multiple parties, and I said to you before, most commercial court cases do have multiple parties. Those kind of factors are hugely relevant as well. Lis pendens, I've already mentioned. And one of the things I said to you was the mere existence, certainly the mere fact that a foreign court got in first is not going to be good enough to get a stay. But again, there's lis pendens and lis pendens. If proceedings were started, if I start proceedings in England today, and last Tuesday, you'd started proceedings against me in Argentina, I think an English court is likely to say, well, I don't want there to be parallel proceedings, but so what? They haven't advanced very far. There could be a jurisdiction challenge in Argentina. It doesn't make much difference. If you started those proceedings against me 3 years ago, and they're about to come to trial, or they've got a very long way, the court may say, it's too late to make a challenge now. So much money has been spent in that foreign forum. It's simply not expedient now to expect me to grant a stay. So again, it's much more flexible how the court will deal with the fact that there are parallel proceedings abroad. It may depend in part where they have got to. But none of these, although it's very close to lis pendens, none of these was the crucial factor in Spiliada itself that caused the English court to say, having said we're going to make it much easier for the defendant, we're going to take jurisdiction in this case, which was the end result. It wasn't much consolation for the defendant, the Cancellex, to be told that they'd made legal history and been the ones who helped to persuade the House of Lords to adopt a more liberal test for staying proceedings, because they ultimately lost. The decision of the House of Lords was that the English court should take jurisdiction. And there was one factor that was more important than, well, the only other factor on the board at the moment is English law applied. It wasn't English law that was persuasive. What was it? Yes, exactly right. Cancellex had been carrying sulphur on other people's ships, and had been carrying sulphur in particular on another ship owned by a completely different person. What was that ship called? The Cambridgeshire. You'll see this mentioned on page 237 in a completely different case called Aerospatiale, which we'll be looking at next week in those going to Junction.
You see on page 237, it's explaining what happened. The same ship, the same charterer had chartered another ship, the same thing had happened to the hull, the bottom of the ship. And you can see 3 lines in on that, page 237, that the English court had already investigated in depth that issue as a test case. Armies of lawyers and experts were already engaged in England on this other case about carrying sulphur on ships. Scientific documents were voluminous in the extreme, scientific investigation. The trial of the Cambridgeshire was begun and proceeded for almost a month when the Spiliada jurisdiction challenge was heard. The single most important factor named after the ship is the so-called, in this case, it was the so-called Cambridgeshire factor. It's nothing to do with Cambridge or County of Cambridgeshire. It has entirely to do with the phenomenon that the same kind of issues were already being investigated in another claim in the English courts. I stress, not a claim by this claimant. But it just seemed a waste to the English court that all this expertise and time and lawyers had been instructed in England. You could get the same ones and it would be so much cheaper and more expedient than having a separate trial in British Columbia or India or Liberia. Let me put it another way, to be blunt. The claimant was very lucky because it got to sue in England, frankly for reasons that had nothing to do with it. But there was another person who started the claim against the same defendant. And I suspect that if there hadn't been another claimant, they'd have started a claim against the same defendant in relation to the same kind of issue, how it carried sulphur on ships that it chartered, that the English court would not have said it was a natural forum for this case. Yeah.
How important is it that it was the same defendants, or if it had been the same sort of facts and the same sort of...
Difficult to answer that question, actually. I don't think it would have been the end of the world for the claimant if it had been a different defendant, actually. I think it's because it wasn't a point about issue a stopper or raised judicata, because there can't be any raised judicata between different parties. It was expertise, just made sense to the court. Of course, you can't force people to use the same lawyers. I think the point was simply, it wasn't dissimilar, it was uncannily simple. How do you carry consignments of salt and water process? Packing things up and then storing them on a ship. That's pretty simple. So to answer your question, I don't think it would have been fatal whether it was the same person or not. I think it was the expertise. And to be honest, a lot of this stuff is actually common sense, isn't it? When it comes down to it. But of course, there's a huge amount of judicial discretion, and there's therefore a huge amount of uncertainty about what the outcome is going to be of these cases. There's no doubt about that either. Should we move on? Let's move on to what I think is the most interesting bit, which is the second bit of the test. Going back to Spiliada, if you look at page 233 on the point that is numbered F, point F on page 233, and about 2/3 of the way down that, the judge says a little bit more about the second bit. And the court says in the second limit that one factor will be the fact that if established objectively by cogent evidence, the plaintiff will not obtain justice in the forum. And then on page 234, there's a much longer treatment of the second limb, which he now describes as a legitimate personal or juridical advantage in litigating it. So we're here at the stage where claimants got jurisdiction as of right over the defendant. Defendant's shown that there's a clearly more and distinctly more appropriate forum overseas. The claimant then turns around and says, yes, but there is a particular injustice to me in having to litigate in that more appropriate forum. Let's say it's Argentina. I should be allowed to sue. Let me give you some examples.
I'm the claimant now. I should be allowed to sue in England because although the approach, the centre of gravity, the natural forum is in other ways Argentina, I can get much higher damages in England. Just shout out if you like. Your gut reaction to that. I'm not asking for anything very scientific. Do you think under the Second Amendment that should be a factor the court should consider relevant or irrelevant? Claimant says, don't make me sue Argentina because I can get higher damages in England.
Depends on the context.
Let me be even cruder than that. Yes or no? What's your gut feeling? Relevant or irrelevant in most situations?
It's irrelevant.
Feels irrelevant. I completely accept that if you're talking about cases of total injustice, and you're not going to get a fair trial, so you're not going to get any money or something. That's different. But in most contexts, I think we get that gut feeling that whether damages would be higher or not would be irrelevant. Remember, it's only 8 or 9 years beforehand in McShannon that the court has said that this sort of factor is an example of injustice. The damage would be higher in England than somewhere else. What about saying, don't let me go to Argentina because I would lose on the merits there, whereas I've got a good chance of winning on the merits here? Again, I'm just asking you to say one word. Do you feel instinctively that should be relevant or irrelevant? Irrelevant. And the point about these factors is, if you're thinking about a set of scales, there's no way in the normal course of event a judge could say that's fair, because if the claimant turns around and says, "I want to sue here because I will get higher damages," what's the defendant going to say to the judge? The other side, if you were on the other side of the fence.
That's uncertain.
Yeah. What are you saying?
The opposite, that they'll be prejudiced, basically.
Yeah.
Potentially going to be liable for much higher damages.
Or I'd much rather be sued in Argentina because the damages are low. What's the judge doing ultimately if he or she says, I'm going to take that into account, that the claimant would get higher damages in England? The defendant's saying, well, the alternative forum, much like the example I had is Argentina. The defendant's saying, I'd rather be sued in Argentina because damages are lower. If the court says, very unfair to the claimant, take that into account, what's it ultimately doing? Is it acting fairly? It's an impartial tribunal, or what's it doing? It's basically taking one person's side. In other words, and this is one thing that Lord Goff said, an injustice within this sense is not something that just because it favours the claimant, it automatically creates the corresponding and opposite disadvantage to the defendant. That's not what he's talking about. The claimant says, I want to sue in England, I get higher damages. The defendant says, I don't want to be sued in England because damages are lower overseas. You can't take sides. Same with the win-lose argument, yeah.
So what about statutory bars? For example, in New Zealand, you cannot sue a personal injury.
That is a very good example, I think.
So the claimant would obviously argue, I can't get justice in New Zealand.
Yeah.
So he can't sue them.
I think the example of where you say, I cannot get justice is much, much more interesting and much more difficult. I've never heard anybody specifically succeed in relation to jurisdictions such as New Zealand by saying that a system that has statutory compensation isn't justice. But I'm not going to have time today, but I'm going to talk about all sorts of examples of injustice, probably on Friday now. So if I haven't answered your question properly on Friday, do call me out on it again. Okay. Let's have a look at some other examples that your Goff takes. So the point I've just made is the second full paragraph after the indent on page 234. You see a paragraph beginning indeed as Oliver L.J. said, an advantage to the plaintiff would ordinarily give rise to comparable disadvantage to the defendant. Simply the favour of the plaintiff is not consistent with an objective approach. That's the sort of I suppose you could call it the third paragraph down on page 234. It's a bit confusing that Lord Goff talks about objective approach. What objective? He just means fair. Objective in the sense of being fair, which is not. So the things that will create that like a set of scales or a set of factors that will create a corresponding disadvantage to the defendant are usually irrelevant. Obviously, there are examples where the foreigner is so unfair that the claimant is not really going to get a fair trial at all in the foreign forum, and we'll talk about examples like that. But in the ordinary course of events, what about things like different rules on discovery, disclosure of documents? Right. This is what the big paragraph on page 234 is an important paragraph. Lordov takes 3 examples, 4 maybe, I think, on about 5 lines into that big paragraph. He talks about damages, which is an example we've already talked about, different rules on discovery of documents, powers to award interest, and different time limits, limitation periods. And what he basically says about those is they're not normally examples of an injustice. What he basically says is, look, England has rules on disclosure of documents. The US has rules on disclosure of documents. It so happens to be that the US rules are wider. We talked about that a couple of weeks ago on disclosure of documents. It so happens that country A has rules on whether you can get interest on a debt, a judgment, and country on what percentage, and country B, the alternative forum, has different rules on that issue. And what he says is, just because a different system has different laws or different procedures, that doesn't mean that they're wrong. That doesn't make them unjust, it just makes them what they are, which is different to the English rules. If you see about halfway through that big paragraph, he talks about, we know there's a spectrum of different systems of discovery in different jurisdictions, ranging from limited discovery in civil law countries to very generous discovery in the US. And he says our procedure is somewhere in the middle. He says no doubt each system has its virtues and vices, but generally I can't see that objectively injustice could be said to be done if a party is in effect compelled to accept one of those well-recognised systems applicable in the appropriate circumstances. In other words, there is a very, very wide margin of tolerance. Just because there are different rules, different procedures in different courts, that's nowhere near enough for a claimant to say it's unjust to have to put up with a different one. Okay. He's not talking about that. There's a very, very, I think which will shorten, particularly in the time available, there's a very long discussion on page 235 of time limits. Supposing I'm the claimant, I'm suing you in England, and the alternative forum is Argentina. Roughly speaking, in England, in most claims, I have 6 years to bring it from when the damage occurred or the breach occurred. Let's say, and you may tell me it's a completely different rule or it's longer, but I don't care. Actually, let's say the rule in Argentina is 12 months. Okay? I've just changed the law in Argentina, so you only have 12 months to bring a claim. You've got 6 years in England. I turn up in the English courts as a claimant and I say, yeah, I know that the centre of gravity of the evidence and witnesses are mostly in Argentina. I kind of know that. But time's run out in Argentina now. It's beyond a year. It wouldn't be fair to send me there because I can't sue there. Remember, that's a jurisdiction in practice. The court in Luba says is a second factor. That's what I'm saying. The court would have had jurisdiction, but I'm too late. In practice, I can't sue there because time has expired. So you've got to let me sue in London, Judge. What's the English judge going to say? Okay. Why do you think no?
Because they theoretically could have sued in Argentina, and they didn't. Wasn't their own, really.
Worse than that, all that's true. It's like rewarding the claimant for their own failure, isn't it? Oh, you let time expire. Oh, well, okay, now you can come into the country. That can't be right, that you benefit from your own failure to start proceedings. The judge will have said, well, you should have got on with it in that case. It depends. There are examples and examples. If the time limit in Argentina is 6 weeks, the court may say that's offensive to me. that's a repugnant law, and you didn't have a chance to bring your claim. Or the judge may say, well, actually, it's 12 months, but I accept that in good faith. For the last 12 months, you've been trying to resolve. You thought there was a big bit of this. You had an alternative dispute resolution. You thought you were going to settle the claim. You thought there was a deal, and then at the last minute, the other side pulled the plug on the deal, and you were 2 days out of time in Argentina. Distilling that whole paragraph, that whole long paragraph on page 235, the most important bit is about 2/3 of the way through it, which is that Lurkov says what we've just said. The fact that a time limit has expired in a foreign court is normally not a reason to make it unjust to grant a stay. But it always depends on the facts. If there is a significant unfairness intrinsically to that limitation, but it's so short that it doesn't. What he says is the onus is, if the claimant wants to make this point, he says about 2/3 of the way through that paragraph on page 235, the onus is on the claimant to show that they did not act unreasonably in letting time run out in the foreign court. There was a positive requirement on the claimant to show it was not unreasonable to let time run out in the foreign court. Okay. Which seems to me to be right. And not many people have got a good answer, actually, to